In this presentation, we will discuss tort law. At the end of this, we will be able to define and describe tort law, define the elements of duty, and explain negligence. Tort can be defined as a wrong that injures another person's physical well-being, emotional health, business, property, or reputation. An individual committing a tort is referred to as the tortfeasor, and the individual who has the tort committed on them is the injured party. The injured party will be the plaintiff as well if the lawsuit has been filed. Once a lawsuit is filed, the tortfeasor, the individual committing the tort, would then be the defendant. The reason for tort law, the purpose behind the tort law, is to find some compensation for the injured party for the offense, for the tort that happened. This can be contrasted from a criminal law, where we know that the intent for the criminal law is some type of crime against the population, against the public, and therefore the objectives between the two are going to be slightly different. In that case, we want to find a remedy. In the case of a tort, we want to deter people from doing wrongful acts from society. With a criminal law, there's going to be, of course, some overlap. If there is a tort that happens, we want to both give compensation to the injured party, and in so doing, we hope to deter tortious behavior in the future. However, the major goal is slightly different than when we look at the criminal law, where the major goal is to protect the public, and that would be through deterrence and or removing an individual that we think might be dangerous to the public because of criminal activity from society. For that reason, although there is a concept of double jeopardy where we can't have the same individual that would be tried for the same crime, it is possible for an individual to be have the same act be taken to prosecute some type of court prosecution through both torts law and through criminal law, because in part of the difference in the objectives between the two. When an employee commits a tort while working for an employee or a corporation, we will typically hold the corporation responsible for the tort committed by the employee. This is going to be called the Doctrine of the Respondeat superior. This is going to be similar, as we talked about, for criminal cases where we hold the corporation responsible for a crime committed by an employee working on behalf of the corporation. And it's a similar kind of idea. When we talk about a corporation in particular, we're talking about an entity, and that form of entity actually has some types of characteristics that are given to them that typically are only given to individuals, such as owning property. And therefore, we want to be able, when we sue a corporation or a business, we're typically suing the business itself, which isn't one individual person. And we have to be able to apply this type of law then to a corporation, which is really a group of people. And one way to do that is to think about the agency kind of concept, where that the employees should be acting on behalf of the corporation. The employees are there to do business for the corporation, and the acts that they are doing are for the corporation, and therefore we can hold the business, the corporation, responsible for the acts of the employee while they're in conduct for that business. One concept within tort law that is important is the element of duty. A duty is an obligation on an individual because of some type of law. So once we determine that there is an element of duty in a particular situation, then we have to determine whether that duty has been violated. Have they violated their duty? Has an individual violated what they should be doing under the law? And if so, then we could say that that violation either happened intentionally or through some type of neglect. In order for a plaintiff to win a court case based on neglect, the plaintiff would have to prove that the neglect caused some kind of injury to the plaintiff, and therefore they are in need or should have some type of compensation in order for the negligence which caused them injury in some way. There are many torts which would fall into the category of intentional violations of duty, including invasion of privacy, intentional infliction of emotional distress, disparagement, fraud, battery, and assault. The concept of battery is offensive or harmful unprovoked touching, while the concept of assault is a fear or apprehension of immediate bodily harm by a tortifier who has the present apparent ability to inflict harm. Defamation, which is a type of slander or libel, is when statements are communicated to others that harms a person's good name or reputation, these statements being false. So we're talking about false statements that are communicated in order to or with the result of harming a person's good name or reputation. Defamation, slander, or libel. False imprisonment is one individual or party is going to prevent another party from moving about freely. That's going to be false imprisonment. Disparagement is another type of false statement, but this false statement has to do with the quality of property or raising some type of uncertainty as to who has legal ownership of property. An example of an intentional tort is the misuse of legal procedure, and that's going to be the idea that we're going to use the legal system in some type of malicious way without probable cause. So we're going to use the legal system to impose some kind of pain through the legal system, going through a process of the legal system without probable cause in order to do so. Another example of an intentional tort is the intentional or reckless infliction of emotional distress, where someone is intentionally or recklessly causing another individual to have emotional or mental suffering. And that's going to be an example of emotional distress or a tort related to the infliction of emotional stress. Even without any accompanying physical injury, the emotional stress in and of itself can be a violation. Note that the emotional stress has to be somewhat extreme because that is something that's going to be more difficult, of course, for us to prove in terms of a mental state rather than a physical state. When we move to the concept of negligence, we know that it is possible for someone to be injured not from a particular action, from a deliberate action, but in this case from some type of negligence, and therefore someone still has an injured party, and therefore the justice would indicate that we would need to compensate in some way the injured party, and we'd need to then determine some factors of negligence in order to prove a negligible case. That's going to include the idea of breach of duty, proximate cause, actual harm, and legal duty. The concept of breach of duty that would have to be explained and determined within a case of negligence would mean that the person who is has a certain duty over the other individual and of course neglected to be duteous enough within that care of duty and therefore would be in some way responsible, if not directly responsible in terms of neglecting that duty. Actual or proximate cause is another element that must be given in order for negligence to be applicable. So it's not just enough to say that someone was negligent in their duties, that in order for the tort law to be applicable, we also have to say that there's actual cause or there's going to be a proximate cause, meaning there's some type of cause and effect relationship. The negligence that has occurred, that we're going to say the negligence occurred, that caused some kind of harm to the injured party. In order to win a case of neglect as well, we'd have to show that actual harm happened. So the injured party would have to show that there was some type of harm that was suffered due to the negligence that has occurred. Legal duty is another element of negligence that must be proven, and that's just going to be the idea that the individual, the tortifier involved, should have some reasonable foreseen knowledge of the risk to the injured party through of the neglect that is taking place. So they should have been able to see or foresee the risk of action or lack of action to the injured party. When considering some defenses to a charge of neglect, how would we defend against a charge of a neglect? Some possible strategies would be the assumption of risk, comparative negligence, and contributory negligence. The concept of comparative negligence is the idea that there's not just going to be a cut and dry case where one person is at fault and the other is not. There's going to be some type of way that we're going to divvy up the responsibility between the parties and then format the compensation in that way. Therefore, we're going to try to look for some type of degree of fault in order to find some reasonable application or some reasonable way to break up the compensation for it. Another defense is the assumption of risk. And that's going to be the concept that, of course, if the person in charge or the person involved should have some awareness as to the risk involved to the defendant, then they could have a defense saying, well, the defendant was made aware of the risk and gave a notification that they were aware of the risk and were willing to take the risk. And therefore, the shift in terms of responsibility would go to the individual, or the argument is that it should go to the individual who took the risk and took it willingly, and therefore there's no neglect on the part of the individual who should have known that there was a risk. It has then been addressed. Another defense against negligence is the contributory negligence, and that's going to be the idea that the person involved, the injured party, did not take careful enough care in order to safeguard themselves against the risk that took place. So here it's an attempt to shift kind of the blame or the fault from the individual that the tortifier or the defendant to the injured party, and the idea is saying, well, the risk is not possibly as high as it should have been if the injured party would have taken the proper steps in order to safeguard against the potential risk. There are going to be cases where we could apply a rule of strict liability, and that's going to be the idea that even though the person, the tortifier, does not have any neglect isn't proven, and there was no intent to harm, they could still be found guilty through strict liability in certain situations. And this would typically apply if there's like a really dangerous type of situation. We're talking about like handling explosives or something like that. We may then go to this strict liability. The concept of cyber torts has to do with the invasion, distortion, theft, falsification, misuse, destruction, or exploitation of information stored in or related to electronic devices, including but not limited to desktop PCs, laptops, mobile phones, mainframe computers, phone cameras, PDAs, and office computers. We have some similar type of torts within the cyber world, including the concept of cyber disparagement, which is going to be the idea of having some type of falsified statement within the cyber world, within the internet, in order to cast doubt on the quality of an item or property or a product offered for sale. We also have the concept of cyber defamation, which is similar to the defamation, but of course, once again, using the computer, using the internet, spreading false and destructive information about individuals with the use of the electronic devices. And then we have the cyber invasion of privacy, which is going to be the unwelcome intrusion into the private matters through the use of electronic devices. When a tort has been committed, then the question is, well, how do we remedy the situation? How are we going to remedy the damages that result from the torts? And typically we're going to be looking at some type of monetary damages. That's going to be the normal default. When a wrong has happened, we're going to try to monetize what type of suffering was there and the damage caused, and then typically put some type of monetary dollar amount on those damages. The concept of punitive damages would be the idea that we have damages above and beyond the recovery damage, and they're there in order to really just to punish, kind of almost make an example of the tortifier that had created an offense that might be thought of as more of an egregious defense or offense. And that would deteriorate. The concept of this would be for it to deteriorate or lessen the likelihood for that individual, as well as other individuals, to engage in the same type of activity. So that would be the concept of punitive damages, and punitive meaning some kind of punishment. So we're looking to have a punishment above and beyond just the recovery of the damages in order to lessen the activity in the future. The concept of injunction is the idea of trying to prevent future acts within the future. So we're actually going to file for an injunction to get a court order to prevent someone from performing, or a company or a party performing, a particular act within the future. For more accounting information and accounting courses, visit our website at accountinginstruction.info.